The evidence question from July of 1996 is another very standard evidence problem. I don't think we'll see any real novel issues here. Rather, we will see standard issues, which are tested over and over and over again on the California bar exam in a rather ritualistic fashion. This question poses 6 items of evidence, 3 for the defense, 3 for the prosecution in rebuttal. So, like most evidence questions, it's something of a racehorse. They will give us 6 fastballs, and we will get around those pitches and nail each issue. Go to the top of the question with me, and we see that we're dealing with a criminal law trial. So we're going to be sensitive to criminal procedure issues that may arise, but as it turns out, there really aren't any. This is a straight evidence problem. The defendant is charged with murder. The prosecution claims that the defendant started a fist fight with the victim, and then when the victim got the better of it, the defendant pulled a knife and murdered him. The defense is claiming that the victim started the fight and that it escalated to deadly violence only because the defendant had to defend himself from a potentially very dangerous attack by the victim. So we've got defense items being offered in evidence. First, we have the testimony of Don that several other residents of the boarding house had told him that the victim was out to get him. So, obviously, we're going to focus on some hearsay issues. This is not an uncomplicated question, but we can give it a pretty straight answer. Next, we have the testimony of Fred, who said that he saw the victim start many other fights. That looks like specific acts, character evidence, and we will raise the appropriate objection. Then, the last item of defense evidence is the testimony of Mindy, the boarding house manager, that, in her opinion, Don is ordinarily a nonviolent person, and that she remembers several occasions when Don walked away from potentially explosive situations at the boarding house. Well, her opinion evidence probably is going to be okay, but we've got more specific acts evidence to have a look at in this testimony too. So now we pause for a moment. Let me make this point. If you're concerned about character evidence, one of the best ways to get sharp at it is by doing practice essay questions. Of course, the other way is keep doing as many multi-states as you can on evidence. I think evidence multi-states tend to be a little harder than evidence essay questions. Next, we focus on the testimony offered by the prosecution in rebuttal. First, the people want to offer a certified judgment that the defendant was convicted of assault with a deadly weapon 8 years ago. Remember, we've got a 10-year rule here, and the prosecution also didn't ask this question of the defendant on the stand. Next, on the prosecution side, we've got the testimony of Smith, another boarding house resident with contacts with the victim and the defendant. Smith is prepared to testify that he overheard Don lie to a census taker about his age, his family, and other matters. Well, we've got more specific acts evidence, and also the prosecutor had asked Don about these incidents during testimony, and Don had denied them. So here we're getting a very good example of extrinsic evidence in the form of Smith's testimony being offered to rebut evidence on a collateral matter. So we'll go into that in a little bit more depth below. This is the key reason why I chose to include this essay in our work together. This item of testimony by Smith. This is a very good example of how this issue is tested, and I think you'll find that my answer is a very satisfactory response. Then, finally, we've got the testimony by Smith in item 6, his opinion that Vic is a peaceful and non-aggressive person, but that Don has a very short fuse. Well, this sounds like legitimate opinion testimony to me on first blush. Take a look at the outline of issues that I've presented, and I think you'll see, once again, just how useful it is to have a very clean organizational approach to any subject, but here particularly evidence, racehorse questions. Have a look at the outline with me. You'll see that I assign a Roman numeral to each of the 6 items. I start off with relevance, and even in the headings, I give the reader some idea about where I'm going. The relevance of Don's testimony is that it supports his self-defense claim. We've got a hearsay objection, and a state of mind exception or exclusion. Then we talk about Fred's testimony. We focus on relevance and the objection with regard to character evidence. And I conclude that this will not be admissible. Finally, for the defense, we focus on Mindy's testimony. Here, she actually has two different items of testimony. We talk about each of them separately. She testifies that Dawn is nonviolent. Here we've got opinion evidence that ultimately we will let in. And then we've got the testimony that Mindy offers about the defendant walking away from explosive situations. This is specific acts evidence, and it's not going to be admitted. Next, we turn to the prosecution's rebuttal evidence. We start off with the certified judgment. There are authentication issues, and then the issue of whether the probative value is overcome by the amount of prejudice. Anyhow, the probative value and prejudicial impact balance is at issue here. These things are often easier to write about than they are to discuss. And then an objection about it being improper evidence for rebuttal. I conclude it's inadmissible. Next, we turn to the testimony of Smith, and I don't like this testimony either. The relevance is somewhat tenuous, but it suggests that the defendant is a liar. The objection is hearsay. I think it's improper character evidence. Ultimately, I don't let it in. Finally, we turn to the evidence offered by Smith. This testimony probably should come in. It supports the prosecution's theory. The objection is opinion and character, and probably we let it in. Okay, let's take a look at the model answer that I've proposed for this fact pattern. And here again, I'm doing precisely what I say we all should be doing in replying to evidence. You'll notice I don't start off with a lot of foolish boilerplate reciting a bunch of doggerel about what evidence is. Instead, I get right down to business and answer the question. When we're dealing with 6 items of evidence, does anybody seriously expect us to spout off a page or two of boilerplate and still have time to really answer the question? Of course not. So let's review my answer briefly. Notice with regard to Dawn's testimony, under relevance, I lead with the facts. We've got a defendant testifying on his own behalf at trial, and he is claiming that other residents had told him that the victim was out to get him. It's relevant because it supports his self-defense justification. We turn to the hearsay objection. These are out-of-court statements, and if he's trying to prove the truth of the matter asserted, the hearsay rule is likely to prevent admission. But if Dawn is, instead, trying to present this evidence to show his state of mind, or the effect these statements had on a listener, it is not hearsay and it's going to be admissible. And if you read my conclusion with some care, I think you'll find that not only do you agree with it, but you find it's a reasonably good example of bar exam writing. Next, we turn to the testimony of Fred. Fred has testified that he has seen the victim start many fights. Again, it's relevant because it goes to the self-defense claims that the defendant is offering. But the problem here is that we've got a character evidence issue. In a criminal case, the rules are somewhat different than in civil cases. And the defendant is allowed to bring in character evidence about the victim, including specific acts evidence. Now, some jurisdictions limit this by particularly with regard to past sexual contact of alleged rape victims, past sexual conduct. So on first blush, our reaction here probably is to find that Fred's testimony should stay out. But a more careful application of the rule of character evidence in criminal trials shows that there's actually a good chance that Fred's testimony comes in. And that's another very good reason for carefully reviewing this fact pattern. Next, we turn to the testimony of Mindy. She has offered 2 ideas. First, that the defendant is nonviolent. And second, that he walked away. The relevance of her testimony about Dawn's alleged nonviolence is that it supports the defense theory of the case. The objection that the prosecution will bring is that the evidence is improper opinion evidence, but still, as the boarding house manager, it seems reasonable to expect that Mindy would be able to see enough happenings to form a reasonable opinion. And so, as lay opinion, her testimony about Dawn being nonviolent is admissible. But her next testimony has a very different fate. She testifies that the defendant walked away from a number of explosive situations. It's relevant, again, because it supports the defense of Don's personality not being a violent one. Here, we've got specific bad acts, or actually here, specific good acts evidence, and here it's inadmissible for the same reasons it would be in a civil trial. Since we're dealing here with the defendant rather than the victim, specific acts evidence will not come in. Next, we turn to the prosecution's rebuttal evidence, and we begin with the certified judgment. The relevance of the certified judgment is that it rebuts the defense claims that the defendant is nonviolent. If he's already been convicted of assault with a deadly weapon, that shows that he's got some familiarity with violence and with the use of force. So clearly this evidence is relevant. A possible objection, anytime we've got documentary evidence, is authentication. If the document is self-authenticating as a result of it being certified, we would be able to overcome the authentication objection. Next, we focus on whether or not this evidence is more prejudicial than probative. And certainly, this prior conviction does not really prove anything about Don's truthfulness. It isn't proving anything about Don's conduct during this incident. And it is very prejudicial to the defense. So that would be one reason why a court might choose to exclude this testimony. Next, we focus on the other objection, improper character evidence for rebuttal. If it's a felony conviction, it's not too old to be admitted because the federal rules allow convictions as old as 10 years. But here, we're dealing with specific acts evidence being offered to show character. And plus, the prosecution never asked the defendant about it before seeking to bring in this extrinsic evidence. Now, since Don has testified in his own defense, the prosecution should have asked him about it then, and their failure to do so could well be interpreted as a waiver that would bar them from presenting this certified judgment. So I conclude the evidence is inadmissible as improper character evidence for rebuttal, and I also think that it is more prejudicial than probative. Next, we turn to the fifth item of evidence, Smith's testimony that Don lied. It's relevant because it suggests that the defendant doesn't tell the truth. The first objection is hearsay, and here these statements were allegedly made out of court. Perhaps Smith's testimony would constitute a prior inconsistent statement, which would be deemed an exception. The other objection, and what I contend is the real problem with Smith's testimony, is it is extrinsic evidence being used to impeach Don on a collateral matter. So this is really the second item of evidence where we've got extrinsic evidence being brought in to impeach. Here it's being brought in to impeach on a collateral matter. And although the earlier questions would be okay, we have to deal with the defendant's answer, and we can't bring in collateral evidence or extrinsic evidence to impeach him on this collateral matter. The bottom line is that the testimony is inadmissible and it doesn't come in. Finally, we turn to the opinion testimony offered by Smith. She's testifying that Vic is non-aggressive, but that Don has a very short fuse. It's obviously relevant, and as we already have talked about in an earlier item of evidence, a lay witness can give non-expert opinion testimony if a proper foundation has been laid. Here we've got Smith, another resident in this boarding house who's got a long acquaintance with both parties, the victim and the defendant. So certainly, this testimony would not be considered improper opinion evidence. Well, is it proper character evidence? Well, yes, because the defense has opened the door to these character issues by claiming self-defense and by presenting the defendant's testimony and the testimony of Mindy and by their efforts to present the testimony of Fred. So it's appropriate for the prosecution to bring Smith in to offer this testimony in rebuttal. I find her testimony relevant and admissible. And that wraps up a consideration of a tricky racehorse evidence question that allows us to review a couple of pretty tricky issues that are commonly tested.